the committee won't skip a beat, and we'll go straight to our next witness, who I think has joined us online. Thank you. Hi, how are you? I now welcome the via video conference representatives from the Executive Council of Australian Jury. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been given to you and is available from the Secretariat. For the Hansard record, though, can I ask you to please state your full names and the capacity in which you appear today?
Peter Wertheim, I'm the co-CEO of the Executive Council of Australian Jury.
And Simone Abel, and I'm the Head of Legal of the Executive Council of Australian Jury.
Okay, great. Now, it may be my IT, but yours is a little wobbly, so we'll let you know, I guess, between the Secretary who's in Canberra, me who's in Cairns, and where you're appearing from today, if we're having any IT issues. Sometimes it's easier, if we do have an issue with the video, if you switch the video off, but we'll still be able to hear you. But we should be able to battle through it. And very grateful for you appearing via video conference today for this hearing. We had originally had a different date, but we've got you here now, so that's fantastic. Do you want to make a brief opening statement before we go to questions, and then I'll hand over the call to other senators?
Thank you, Madam Chair. Just a very brief opening statement. And by the way, we can hear you loud and see you loud and clear. On the 9th of October 2023, 2 days after the worst massacre of Jews since the Holocaust and the well-documented systemic rapes of people in Israel by the terrorist organisation Hamas, protesters in the forecourt of the Sydney Opera House burned an Israeli flag and chanted "F the Jews," with a police investigation determining that "Where's the Jews" was also chanted. The incident shocked Australia and shocked the world. Yet nothing was done to bring those responsible to account. No one was prosecuted under any of the provisions of the Criminal Code or under any other law. Since that incident, there has been an unprecedented surge in public demonstrations promoting racial and religious hatred, setting Australian against Australian and community against community. We have seen self-described religious preachers spewing hate to their followers and online against the Jewish people and the LGBTIQ community, street and university protests displaying degrading and dehumanising slogans, and many other unprecedented acts that have shattered the peace and harmony of our society. Again, none of these incidents has resulted in those responsible being prosecuted. The first question this inquiry needs to address is whether it believes that Australians will simply have to keep living with the sort of behaviour we witnessed at the forecourt of the Sydney Opera House last year. My community, and I believe the vast majority of Australians, are astonished that this question even needs to be asked. Of course, the answer should be a resounding no. To continue to tolerate such behaviour is a foolish and short-sighted approach. The lesson of history is that failure to act against racist and other hate speech invites an escalation to more aggressive behaviour and ultimately to violence and worse. If this inquiry concludes that the law is supposed to address the kind of social harm that was done at the Opera House last year, then the second question it needs to address is whether the bill now before us will achieve that purpose. On our analysis, as set out in our written submission, the answer to this question is also no. The recommendations we have made arise from the long experience of the Jewish community in Australia in witnessing the failure of anti-incitement laws and serious vilification laws that have been enacted federally and in the states and territories when applied in real cases, with only rare exceptions. We urge this inquiry not to allow itself to become yet another link in that long chain of failure. Thank you.
Thank you very much. and we've just clarified it is a little patchy for me, but for everyone else it's fine. So we're just going to proceed, and I'll hand the call over to Senator Scarr. Thanks, Senator Scarr, for understanding. I might not have heard all of the opening statement, but we've obviously had the Executive Council of Jury in front of us at other hearings. So I've got your written submission as well. Senator Scarr, are you ready to ask questions now?
Yes, I am. Yes, I am, Chair. Mr. Wertheim, can you hear me?
Perfectly.
Excellent. And Ms. Abel, good to see you again.
You too. Thanks, Senator Scarr.
Mr. Wertheim, I thank you for your opening statement. Thank you for your submission, and thank you for the passion underlying your opening statement, which I think is something which causes deep reflection in myself. One of the issues I'm grappling with, to be open with you, is are the laws as they're proposed to be amended advancing the cause at least somewhat? Therefore, because of the current situation, which you once again reminded this committee of, as it pertains to our Jewish community, is something which we need to at least make these changes in the shorter term, and then look at more substantive reform, perhaps in the longer term. How, from your perspective as a leader of the community, how do you see us balancing those issues? Because obviously just to expand on that point, lowering the bar to recklessness is obviously something which should theoretically, and I note it's theoretically, make it easier for prosecutions to be brought under these provisions to address the sort of conduct you outlined, as would removing the good faith defences. But from your perspective, there's still an obvious concern that still there are these barriers, the offences are too complicated. It's just going to be too difficult in practice for these offences to be mobilised, if I can put it that way, to address the despicable acts which we're seeing in the community today. How do you balance those competing concepts of, well, trying to improve what we have, as opposed to making it best practice, if I can put it that way?
Thank you, Senator, and thank you for your question and the concern that you bring to this issue. We've had some discussions in the past about it, and I thank you for your interest. To summarise the position from our perspective, we think that these proposed changes in the bill are just tinkering around the edges of the current law and do not really grasp the nettle. And we've seen this sort of approach by other parliaments in relation to similar laws in the past. I'll give you one example very quickly. In New South Wales, there used to be a provision called Section 20D for David of the Anti-Discrimination Act, which dealt supposedly with serious vilification. It was on the statute books for decades. Not a single prosecution was ever brought under it. In 2013, there was a parliamentary inquiry into that particular provision. It recommended some procedural changes and some changes around the edges of the provision, but didn't grasp the nettle. And in the end, 5 years later, the Parliament was compelled, under the pressure of circumstances, to scrap that law entirely and to come up with a new one, which has its own problems, by the way, but that's another story. So the difficulty we have with the current law, and we've set out our reasons at some length in the submission, is that it doesn't overcome the sources of the difficulties that prosecutors have had in practice in applying the law. And that includes applying the law to the Opera House forecourt situation and other situations. One of the principal obstacles is the use of the word incite. which has a complex meaning at the best of times in the eyes of the law, and a very almost impossible to enforce meaning when it comes to the criminal law, where the evidentiary standard is beyond reasonable doubt. So that has proven to be an obstacle where a prosecutor needs to prove that a particular action involved incitement with intent, urging people to a particular course of action. And as we said in the submission, and as this Senate found in 2014 in connection with its inquiry into terrorist-motivated violence, language is much more subtle than that. Yeah. It does not lend itself neatly to that kind of paradigm. And so we have urged that the Parliament look at other words that have been used, for example, with regard to urging of terrorism offences, where the word advocate or promote or some similar verb is used, or a series of verbs, which is more realistic in the current circumstances and which has better prospects of a prosecutor in an appropriate case securing a conviction. And of course, the other difficulty we have is the double mental element, which is extraordinarily unusual in the criminal law. It's hard enough for a prosecutor to prove one mental element. To add another mental element to it seems to be counterintuitive. And I would say that most Australians would think that if somebody intentionally or recklessly, without regard to consequence, promotes or advocates hatred or especially violence against another group of people on the basis of race, religion, or other attributes, that is already a criminal offence in their minds, and they'd be astonished to find that that's not the case.
Do you know the background to this second element? So I've doing a deep dive into these provisions, and as you say, it's a curiously drafted provision, because you've got this double mental element. First, the first person urging another person to use force or violence, intentionally urging another person or group to use force or violence or recklessly, but then the first person does so intending or reckless as to whether or not force or violence will occur. What's the second element trying to get at? Because like you, I'm looking at this and thinking, well, if you're recklessly urging, or even using your words, promoting, advocating, or glorifying the use of force or violence, what more do you need? Surely that's clearly a hate crime. It's clearly against the public good. It's clearly is posing a risk to groups in our community. It's clearly unacceptable. It's clearly connected with force or violence. So it can't be defended as any form of freedom of speech that is recognised as being legitimate. What's the purpose of the second mental element? Do you know what the background is to that?
I believe I do. You have to go back to the introduction of sections 80.2a and 80.2b of the Criminal Code in 2010. That was preceded by a parliamentary inquiry. It was also preceded by an inquiry by the Australian Law Reform Commission. And the Australian Law Reform Commission, not unnaturally, and this is not a criticism, but it takes an ultra-civil libertarian view of these sorts of issues. And I think this is the legislation that ensued, the legislation we have now, which doesn't work, is a consequence of that approach, where an ultra-civil libertarian approach has been taken in the abstract without regard to the real-life situations in which these sorts of events occur. And the Australian Law Reform Commission recommended that second mental element. But just pausing to think about it for a minute, taking the current legislation at face value, imagine you have a situation where a prosecutor actually proves to the criminal standard that a perpetrator or an alleged perpetrator intentionally has incited violence against a person or group on the basis of their race, and has also proved beyond reasonable doubt that the perpetrator intended that violence would occur. In what universe is it possible to have that confluence of intentions, and yet the perpetrator is somehow acting in good faith and can avail themselves of a defence under Section 80.3? It just doesn't make sense. I've never yet spoken to a lawyer who says it does make sense. And so this is the legislation we have now is a result of that flawed approach.
So one of the obvious issues that it seems to me arises from this, and I'm beyond the good faith defence, right? I understand the argument that's being made in relation to good faith defence, subject to one point which I'm going to raise with you on a subsequent question. But that's clear to me. But it would seem if you're going to have this torturous process of having double intention, that someone who faces a prosecution under these offences can simply say, the way the legislation's drafted at the moment, that, oh, I might have said that, but of course I was carried away with my rhetoric, I was emotional, I misspoke, etc., etc. And then it comes down to a state of mind issue, and you can see the complication in trying to actually bring a prosecution under the existing offence. Is that the concern? One of the concerns?
Well, it is, but the onus is on the prosecutor to prove the intention. Yeah. And so if somebody is just venting, as they do, then it's arguable that the requisite level of intent or even recklessness may not have been present. Certainly the intention was not present. Recklessness is a bit more tricky because, as we know, the standard of reckless disregard for the consequences is it's above mere negligence, it's above mere inadvertence, but it's just short of intention, and it's a difficult one to define even in the abstract, let alone to apply in real life situations.
Yeah. Okay. The Australian Human Rights Commission has proposed some words. Have you had a chance to have a look at their submission?
I regret that I have not.
That's okay.
I'm happy to do so.
And I suspect I know what your reaction is going to be, but they're proposing words that they say are consistent with something the ALRC proposed. So if they're saying, look, the good faith defences drop away, but you still need something which looks at context, and they're proposing that consideration should be given of the context in which the conduct occurred, including whether or not it was part of some artistic work or genuine academic, artistic or scientific purpose, genuine purpose in the public interest, connection with an industrial dispute, the dissemination of news or current affairs. Can I ask you to take that on notice? Interested in any initial view you've got, but I suspect I know what it is. But if you could take that on notice and just give us a formal response to that, but whatever you'd like to offer now.
Look, I'm happy to deal with it now, and if you think it needs a further response, I'm happy to put that in writing. But essentially, as we've argued for this inquiry and for many previous inquiries about this, where there is a genuine academic or artistic or intellectual purpose, the requisite intent can't be established in the first place. The guilty mind is not there. If the purpose is to give artistic expression to a particular theme or to explore an academic situation, a historical situation, for example, and understand how racism has ruined societies and led to genocides and crimes against humanity in the past, the requisite intent is not there. And I would also add that the standard of recklessness could not be met either. No prosecutor would take on a case like that in those circumstances. So I just think it's a non-issue because you don't get to first base with the elements of the offence that a prosecutor has to prove from the outset. The first point you raised about context, I think is already inherent in the law in any event, but I would have no objection to making it explicit. A court is obliged to look at the totality of the circumstances of an alleged offence in coming to its conclusions. You cannot judge a person's intentions without looking at the full context, and that would include not just the audience to whom the words are addressed, but what else was going on in society at the time, and perhaps a lot of other things as well. So I think that's already there in the law. I think that's what courts do as a matter of course in any event. But if it's a matter of making that explicit and that gives some comfort to people, I have no problem with that. And if you're looking for a halfway house, and this is not in our submission, but I'll put this on the table. If the concern is that innocent people might be inadvertently caught up in a law that sets the bar too low, why not, at least as a first step, use the words that we're proposing, advocate, promote, glorify, and restrict it just to intention, not to recklessness, and get rid of the second intentional element and get rid of the defence. Now, to me, that might work, and it might carry with it the realistic possibility that a prosecutor in the Opera House forecourt type situation could get a conviction.
Yeah. So from your perspective, if you drop that second element of the second limb, if you like, of the mental element, and changed the words to refer to promotes, advocates, or glorifies, which is a formulation used in other contexts, that could actually provide a tighter definition to capture the concern about conduct, yeah?
Correct. In other words, you broaden the scope of the actual action you're seeking to capture, but narrow the scope on the intentional element, on the mental element to intention.
Yeah, okay. I see that. I see the logic of that.
Scott, I'm conscious it's only yourself and myself asking questions on this panel, but I do have a series of questions I need to put as well. If you've got one or two more questions, and then possibly I could share the call, and then I can come back to you if we've got more time at the end.
Okay. Well, I might, Chair, I might just raise two quick issues, and I'll raise them in the one question to just make it as easy as possible to make sure you've got the opportunity to ask your question. So some previous witnesses from Equality Australia raised an issue around expanding the scope of the offence to include threats of damage against property owned by people who have the attribute. So it might be a business premises, it might be, we've seen an awful despicable acts in the eastern suburbs of Sydney recently. So interested in your view with respect to that it's a manifestation of a hate crime which is occurring today. We're seeing it today. And secondly, potentially expanding the scope of the offence to include people who are providing support to a community or associated with a community, so they might not have the particular attribute themselves, but it might be, say, a leader who's giving support to the community and is receiving threats because they're giving that support. It might be someone who's potentially hosting an event for the community, receiving threats of violence or force because they're hosting that event. So interested in your views on those two issues, and also feel free to take on notice if you'd like some chance to reflect.
Oh, I don't need to reflect on that. I agree with them both. We have almost a identical position on these issues to Equality Australia. I've had discussions with their principal officers over it, and I think those two suggestions are very valid, and we would support them.
Okay, thank you.
Thanks, Senator Scarr. I really appreciate it, and thank you for your time today. Well, I can't speak for the Attorney General. I wouldn't attempt to, but I think our committee has had a strong reputation of making really worthwhile recommendations that are taken on board by the government. So I am really keen to understand the elements of the bill. I understand you support the bill in the way that it's put, but there's an extension, or you like the bill to go a bit further. And that's,
a lot further.
Yeah, and that's really of interest of me, and I hope, I hope that's something that we can get sort of broad support around for if there is a view that needs to go further, that we can get, all sides of the parliament on board with that as well. So my questions are going to sort of focus on that. Before I go to that, though, I know that you speak about this publicly all the time, but just for the purpose of our committee, I wanted to get some comments from you about the escalation you referred to in your opening statement. I'm not sure, do you know Rabbi Ari Rubin? He's sort of referred to as the Outback Rabbi. He covers from Cairns all the way to the Cape and Mackay, so he covers most of regional Queensland. And there was a really disturbing article on the weekend where Rabbi Ari spoke about the rise of anti-Semitism even in our regional communities. And there was a sort of disturbing quote that one of the members of his community said that he had told me that he is absolutely afraid to walk down the street with his kippah on. He definitely is now changing his habits and not going to be walking around visibly Jewish anymore. And I know this is well documented in the media, but I just thought for the purpose of this committee, if you could explain why we need these laws, but why the escalation towards violence is what we're seeing in the community at the moment.
Thank you. It's a great question. Well, look, we're very familiar with the article you quoted. In fact, the article cites our organisation and the report that we just published last week about the massive increase in the number of anti-Semitic incidents that have been reported in Australia over the last year. The Executive Council of Australian Jewry has been publishing these reports about anti-Semitic incidents since 1990. And they come out every year. They cover a particular 12-month period. And we have seen in the past increases and decreases. When there have been increases, they've been 20, 30, 40, 50% even. There have been some years where there have been decreases. But we have never in that 30-year period seen an increase in the number of reported anti-Semitic incidents of 316%, as we saw over the last year. That's totally unprecedented. It's off the charts. And so the rabbi's concerns are well-founded. They are supported by statistics. We don't claim to be perfect in our recording, but I think we do a pretty good job, and our statistics have been relied on and cited many, many times by this Parliament, by governments, by human rights organisations and the media. So we're quite certain that the statistics that we've published recently provide a fair longitudinal comparison to what has happened in the past. And what we're seeing is very, very concerning. Yeah. And we also know from other studies that have been done by Monash University, among others, that the number of reported anti-Semitic incidents is understated severely. So we're seeing situations now where people can't, like a rabbi, cannot walk down the street safely wearing a religious head covering. Jewish school children who go to a Jewish day school are afraid to wear their uniforms on public transport lest they be abused, where people have lost jobs because of doxing, or lost their businesses because of that, where there has been exclusion of Jewish artists in the arts and culture space, and of course the university encampments and the treatment of Jewish university students and staff, which has been the subject of another inquiry of this Parliament, well, by your committee and more recently by the Parliamentary Joint Committee on Human Rights. So we're not making this up. This is a real and empirically verifiable phenomenon.
And I guess the reason, sorry to cut you off, I guess the reason I had given that example, there were some other examples in that article, but of course you've provided some and you've spoken in your opening statement, which I didn't get all of it because of my IT issue. But what I was really interested in understanding is the recommendations that you've made to the committee, particularly around a serious vilification offence, and that any such offence not contain a good faith defence. What are some of the cases of anti-Semitism that would be covered by the proposed amendments to the bill? So I guess we can have a legalistic debate about that, but for a practical point of view, so that senators on the committee, but other members of the public can understand, what are the things that are happening at the moment that you'd like to see covered by proposed amendments to this bill?
Okay, well, at the risk of repeating something I said in the opening statement,
I'm sorry, I didn't
hear you now. Yeah, so, I mean, we've seen, for example, self-described religious preachers addressing their followers and going online with some extremely graphic anti-Semitic statements, calling Jews vile, despicable people, buying into classical anti-Semitic tropes about Jews controlling the world's media and the banks. I mean, I can give you a compendium, if you like, of tropes.
You can provide someone notice if that's easier.
And we speak also about, in our submission, we speak about this one example where the language that was used was actually the final solution. So, where a preacher stood up and spoke about the Ummah and a spark to the final solution. Those words obviously have a particular meaning to the Jewish community, because that was what Hitler referred to as the extermination of the Jews, the final solution.
And interestingly, when a member of parliament used that expression some years ago in connection with immigration law, I mean, it caused a huge furore, and rightly so, because it's not just a meaning that is conveyed to the Jewish community. I think it's now entered common parlance as well.
Yeah.
And I mean, this is the sort of speech that, if it's left unchecked, can create a permissive atmosphere in which people feel emboldened to ratchet up their level of hatred to further an even more extreme speech, and then ultimately into acts of violence, as we have recently witnessed, and which Senator Scarr alluded to a moment ago.
Yeah. And just to build on that, a lot of the time the language is very coded, but it has specific meaning in different religious contexts. So, for example, in some religions, being a thief might mean that you have your arm amputated. So obviously when you hear public language about Jews being thieves or Jews stealing land, that may potentially have implications in terms of urging some kind of violent action. So the language can be coded and subtle perhaps to members of the general public, but it's certainly not subtle to the audiences that it's reaching, who have a shared understanding of what that language means. And we've seen this in many contexts.
And is that why you said that there's an underreporting of anti-Semitic incidents? Is that because some people don't quite understand the intention or the maybe the meaning behind some of the references? There's a specific example that I won't go into because I don't want to interfere with investigations. But I'm aware of people cleaning off graffiti, not knowing that it was anti-Semitic before they took a photo of it to record it. But is that why that is sort of underreported at the moment?
I think the reason that Jewish people don't report every anti-Semitic incident that they experience or witness is because, firstly, they don't believe the law can deal with it effectively.
Yeah.
And that's what we're talking about today. And secondly, they don't want to become personally involved in having to become a police witness or become involved in some legal proceeding unless there's some reasonable certainty of a successful outcome, and they just don't have that confidence.
This we spoke to the Australian Human Rights Commission earlier today, and they spoke about this these types of laws doing two things: sending a message to the community about appropriate behaviour and what is criminal and non-criminal behaviour, but also to prevent that escalation to the next level of violence, hopefully. You talk about, you've spoken with Senator Scarr in quite some detail about the lowering of the intention threshold that's in this bill, and recommending removing the second element of reckless that force or violence will occur from the offence. Why do you think it's important to have that lower threshold? For me, I can see in incidents where there is that escalation, and I think that there is an argument to be made that we stopping it at that level before it gets to the next element is an important thing to do, but I'm really keen to hear your views.
So what I was proposing to Senator Scarr as a kind of compromise that this committee might look at seriously, and one which I believe might be more palatable to those who are primarily concerned with civil rights, is one where there's a lowering of the bar, or a widening of the scope, I would prefer to call it, when it comes to the range of conduct that is caught, but a raising of the bar when it comes to the mental element. So that the mental element is just intention, not recklessness. And I've had conversations with colleagues in other faith communities who are particularly concerned that ministers of religion, in the course of making an ordinary sermon, might be quoting some religious scripture or what have you, and might be inadvertently caught by such a provision. And I said, but in those cases, you would never say that the minister of religion intended to promote, advocate, or glorify hatred or violence against another group on the basis of their race or religion or even their sexual orientation. And they, the conversations I've had, everyone's agreed with that. No, they would never have intended that to be the case. So if intention is the mental element, it might possibly give some comfort to those who are worried about the unintended consequences of such a provision.
Thank you. I put this question to other witnesses, and I thought I might ask you as well. One of the points of opposition to the Commonwealth introducing or establishing an anti-vilification provision might be that, look, the states and territories deal with that, let them be the ones that police that sort of thing. The Commonwealth doesn't need to duplicate those types of laws. The Attorney General said, I think in his second reading speech, that actually this is intended to fill in some of the gaps that exist. What about the gaps in anti-vilification law? Is there a benefit to the Commonwealth pushing that forward?
Yes, definitely. I mean, we are one country. It is a good idea generally to have the same rules apply to everybody rather than have a different regime apply in different states. We already have a Commonwealth law against racial vilification at the civil level, in the form of Part 2A of the Racial Discrimination Act. It seems to me that there's no good reason not to have a uniform criminal law across Australia about that, but certainly a federal law that will complement state and territory laws and ensure that whatever gaps there are in those state and territory laws are filled by having an appropriate law that covers the whole Commonwealth.
Okay, I'll hand back to Senator Scarr if he has any other questions. One last thing just to get your view on. I asked the Australian Human Rights Commission if a threat of violence could ever be made in good faith. I think the pretty obvious answer was no, but there's your submission notes removing the good faith defence for existing offences is a good thing to do. Can you just expand on the reasons why that defence is inappropriate?
Well, I think you pointed the way already, Senator, in your question, and I respectfully adopt what you just said. If a person intentionally, and we would say even recklessly, promotes, advocates or glorifies violence against other people on the basis of their race or religion, sexual orientation and other attributes, it seems to me that mental state of intention or recklessness, reckless disregard for consequence, is incompatible with the very idea of good faith. The urging or promotion of violence by one Australian against another simply on the basis of a personal attribute is the antithesis of good faith, we would say, especially in a democratic country.
Yeah. Senator Scarr, do you have any other final questions? I know we've got a few more minutes and I did want to hand the call back to you if you had time.
Just one further matter to tease out, if I could, Chair.
Of course.
And that is this, and again, this is I must say, I find these offences just so complicated, and they're like a cryptic crossword puzzle in some respects, right? And I was never good at cryptic crossword puzzles. This concept in the new offences that it's an offence if the person threatens to use force or violence against a group. The targeted group is distinguished by one of the relevant attributes. And then the third element is a reasonable member of the targeted group would fear that the threat will be carried out. And I'm trying to work out what that third limb adds. Now, if and why it's necessary. So if someone actually threatens to use force or violence, I would have thought on face value that should be considered if you prove the relevant intention, that should meet the threshold. Why do you have to consider whether or not a reasonable member of the targeted group would fear that the threat will be carried out? Why put the onus on the prosecution to prove that someone who's a member of the targeted group would, listening to the words, think that person has the capacity to do it, or doesn't have the capacity to do it, or will do it, or won't do it? So I'm interested in your thoughts with respect to the how that may be appropriately addressed to take into account that concern.
Well, that's the problem with threats of violence. You don't know whether they're likely to occur or not. You're forever looking over your shoulder and having to worry about it. And no citizen should have to put up with that. It's the job of government to protect us from that sort of situation. And so it seems to me to be just a drafting quirk that has been added to that particular provision to maintain some sort of symmetry with the current provisions, which, for the reasons we've been discussing, don't work. I think it's just an extra requirement that has been put in there to satisfy some abstract civil libertarian principle without regard to the real world consequences.
Well, I'm trying to even understand what the abstract civil liberties principle is as someone who cares about civil liberties and freedom of speech, because if you actually threaten to use force or violence against a member of a particular group, well,
that should be
that's
enough.
what you've done. I'm not sure why we need to search for something else. Threatening the use of force or violence against someone is unacceptable.
And that's why, I mean, that's been the problem with these laws. They're Clayton's laws. They're laws against incitement to racial and religious hatred that you have when you don't really have a law, because they've never been used. I don't believe there's ever been a prosecution, certainly not a conviction. And the provisions that have been put to us in this bill, in my view, are unlikely to alter that situation in the future.
So, as I understand it, Mr. Wertheim, one of the proposals you make in relation to that subsection C, which is in both 80.2BA1 and 2, is that C, to the extent it's needed, could be converted into a defence such that it might provide an avenue for someone to say, well, no reasonable person would think when I said that I was saying anything other than some sort of high-blown rhetoric, which I was never going to act on. Is it something which, if it is to be included, it's more appropriate to be included as a defence, and then put the onus on the person who's actually threatened to use violence to actually demonstrate that it was something which no reasonable member of the targeted group could interpret as a threat that might be carried out?
Yes, I believe so, and it would be a defence that would directly address the mental elements. So it's appropriate that the person who carries out the conduct is the one who has to explain the conduct.
Yeah. Just one last question, Chair. Sorry. I just want your views. There's this distinction in terms of penalty between a threat, if carried out, would threaten the peace, order and good government of the Commonwealth, and the lower offence, if I can put it that way, doesn't have that extra limb. Is there any law you're aware of as to how you discern whether or not an offence threatens the peace, order and good government of the Commonwealth?
I think that it goes back to the old sedition type offences in the Crimes Act, and it's just a recapitulation of those sorts of provisions. I don't think a lot of deep thought has been given to including those sorts of provisions in this legislation. And I don't think
the only thing I could think of was scale, right? So if something on a larger scale or seeking to urge force or violence across a whole community as opposed to against an individual, that might be one of the elements you look at. But there's no other insight you can give us in that regard?
No, it would be something that would go to penalty rather than guilt or innocence.
Yeah, okay. Thank you. Thank you, Chair. Sorry,
You're right.
Just can't hear you.
Sorry, I was just saying thank you very much, Senator Scarr, and thank you to you for your appearance today. We've gone a little bit over time, but we understand your very keen interest in these laws, and for Senator Scarr and I to make some good recommendations in regards to them. So we will endeavour to do that. Thank you very much.